Honorable members, good morning and a warm welcome to the second day of this orientation program. Today we have 4 sessions in the morning and 2 in the afternoon. We are indeed thankful for your active participation. We begin now with the session on parliamentary privileges, and it's a privilege to have Dr. Abhishek Manu Singhvi with us. An eminent lawyer by profession, Dr. Singhvi is a third-term sitting MP in the Rajya Sabha. He is presently the chairman of Committee on Home Affairs. He has the unique distinction of being India's youngest designated senior advocate at the age of 34 and being appointed as Additional Solicitor General of India at the age of 37. He is also a well-known author, columnist, and a visible media personality. Seated with him on the dais is Mr. Jagdish Kumar, Additional Secretary, and Mr. Mukul Pandey, OSD. Without wasting any more time, I request Dr. Singhvi to address the honorable members on the subject.
Namaskar, good morning. Sunday is always a slow start, but this is a different kind of whip which all of you are obeying on a Sunday. And it's good to see that people are making this attempt. I've had the unique privilege of doing it twice in a row running, including in 2021 during not so pleasant times. But it's truly a privilege to speak to a privileged club like members of parliament on the subject of privilege, parliamentary privilege. It is of course an irony that India has made such great strides in the last several decades, globally, otherwise, and yet on one thing we are consistent with global trends: the general declining image of politicians, a cynicism about institutions like parliament, a general anger against all who are perceived to be the beneficiaries of pelf and power. So it appears sometimes to me in a lighter vein that the only privilege which members of parliament appear to have is the privilege of being mocked, criticized, vilified, and made fun of. But that is a little bit of an aside. Let me turn to the subject straight away. We have 45 minutes and I can tell you that we will barely be able to cover it. I want to leave some time for questions, answers for those of whom you are interested. Friends, the concept of parliamentary privileges arose from the mother of all parliaments, British. And therefore, that historical lineage can never be severed, because that is true of all countries where parliament is an institution and where parliamentary privileges are a subject. It arose in the hoary past, and there were various trends in Britain when, at one level, parliament was a group of people simply, or a council, virtually standing up in a sense to battle against the king. The king was rolled into everything: executive, legislature, and judicial in one sense. And that royal element was the antithesis of democracy. And therefore, while the king's judges were timid, Parliament tried to stand up. And ultimately it was one such council called the Witten Council, basically like an assembly of people. You could say in the Indian context a very large panchayat, which had this great council meeting in 1215, where the Magna Carta was proclaimed. These were all declarations against the king. We have rights, we have fundamental rights, we have this right, that right, and you, the king, can't take it from us. And then it evolved slowly in the 14th century. In 1362, for example, they said Parliament must have the right to approve all taxation. You can extract money from the citizen, but only if Parliament has approved the law. You can't just go and say, pay me taxes. In 1376, Parliament, I mean, it was a different kind of Parliament, but a group of people which you can consider to be Parliament, they had by then started calling themselves the House of Commons, tried and impeached some of the king's advisors who they felt had gone against Parliament. Then there were many, many years of struggle, and I'll skip that long history. There was in between a English civil war also, and you had what might be called a democratic dictator, Cromwell, who went against the king, but he also went against Parliament. He became initially elected as a dictator, and then he abolished all institutions and made Parliament also a puppet. That went on, and then in the 15th century, Parliament started asserting its rights more and more. Finally, in 1621, King James I repeated what other kings prior to him had repeated. Said, you Parliament have only got privileges as a license of what I give. You have privileges at my sufferance. Immediately Parliament, this is 17th century, protested. They said these are our privileges. They are not at the sufferance or the largesse of the king. At which time the story goes that King James tore out the pages of the parliamentary proceedings which said so. Finally, a Bill of Rights came in 1689, which in writing confirmed that in principle Parliament has privileges which are unique, and in particular the privilege of speaking in Parliament without fear of being intimidated, sued, imprisoned, etc., etc. In 1704, since the Parliament's privileges were being asserted, and since the Bill of Rights recognized it, they had a bit of a climb down by saying, yes, we have privileges, but we agree that what we have, but we can't create new privileges. These are all historically very interesting things 300 years ago, which are all relevant today and which are all discussed today. So they added this, that A, you have privileges, B, we have not defined them, C, we cannot increase or decrease what we have, and 4, these privileges also apply and endure for the proceedings of Parliament. In England, that book is called Hansard, what we call the record of proceedings, what the Secretariat publishes every day in the bulletin, etc. So friends, let me start with simple definitions of what is parliamentary privilege. Parliamentary privilege, one simple way of describing it would be the reference to those rights and immunities enjoyed by Parliament as an institution, that is, as a body, and also by MPs in their individual capacity, without which they cannot discharge their duties as members of Parliament entrusted upon them by the Constitution. So this is the basic point. It is given to you to make you more effective and efficient in the discharge of your parliamentary duties. Collectively, it has been said that it includes several rights. For example, no arrest, which is clarified later to mean no civil arrest. Criminal arrest can be done. There used to be, and there is still a provision, which many of us don't know, that if you don't have debts paid for a long time, you can have civil imprisonment, civil prison. That is not allowed for members of Parliament as part of their privileges, but not criminal arrest. And the privilege that no court can look into and investigate proceedings inside Parliament. Some of these are codified in articles of our Constitution. Thirdly, the privilege of, these are the collective ones, not individual ones, I am talking of the collective institutional privileges, that you can exclude guests or persons from parliamentary proceedings according to the chair's wisdom and discretion. And fourth, you can punish So like a court can punish for contempt, you can punish. These are broad parameters of parliamentary privilege. Article 105 of the Constitution makes one attempt at balancing free speech and parliamentary privileges. And if you just give me a second to read 105 to you. Powers, privileges, etc. of the Houses of Parliament and of the members and of committees. Of course, remember, all the privileges of Parliament attach to committees also. It is not that committees do not have privileges. Subject to the provision of the Constitution and to the rules and standing orders, there shall be freedom of speech in Parliament. That is how it opens. Second, no member of Parliament shall be liable to any proceeding in any court in respect of anything said or any vote given by him in Parliament or any committee thereof. And no person shall be so liable in respect of the publication by or under the authority of either House of any report, paper, votes or privileges. And the third subclause of 105, it has three subclauses, makes it clear that the privileges shall be that as may be defined from time to time by Parliament. The privileges are those which Parliament may choose to define from time to time periodically, but till such time as Parliament defines it, they shall be as they stood in 1978 on 20th June 1979 when the 44th Amendment came into force. And it will apply, the last clause, the fourth clause says, it will apply to all those persons who, though not technically MPs, are also obliged to discharge parliamentary duties, and I'll come to that subject in a minute as to who those persons are. So you see by the structure that free speech inside Parliament of you as a member or me as a member is 100% protected. Subject to, of course, rules of Parliament itself. I can't get up and start abusing you by name inside Parliament, though I have free speech inside the House, because that is subject to our relevant rules. Freedom of speech which you have is limited to Parliament. And the no liability exemption is limited to Parliament and what you say or do in Parliament. Now, of course, this last part in 105(3), which said that the privileges will be either defined by Parliament or till such time as they are defined, they shall be as they stood in the 44th Amendment. The earlier version was as they stood in the English Parliament, or as are the privileges in the British Parliament. And Mr. Shanti Bhushan and then Law Minister moved an amendment saying that it doesn't behove a proud country like India to make reference to a former ex-colonial power in the Constitution. So we will make sure that whatever is standing today, he moved the amendment in 1979, and therefore this change has come, that whatever stands, otherwise this clause took you back to the privileges of the British Parliament. Let me turn, friends, to various issues arising. Issue number one is obviously, should we codify parliamentary privileges? So should we not pass a law putting all privileges, that parliamentary privilege of MP is 1, 2, 3, 4, 5, listing it. That's what the Constitution also says, that Parliament can by law codified, and what is prevailing in the 44th Amendment will be the privileges only till so long as Parliament chooses not to codify. Well, friends, there's a lot of debate on this. There have been various committee reports. Some have suggested yes, codify. Some have suggested don't codify. Till today, we have not codified. What is my personal view? My personal view is we should not codify. Let me give you some reasons for it. It's an interesting facet which people tend to, a lot of you think that codification will make your power stronger, that you will have a very great specification of power. So why do this is my personal view, mind you, it is not anybody's view. Why do I suggest that you should not codify? You know, codification makes a statute out of parliamentary privileges. So Parliament will have to pass a law saying the parliamentary privileges are 1 so and so, 2 so and so, 3 so and so. The moment you are specific and statutory, you immediately invite court scrutiny, court review on words. You start nitpicking and fighting on words. इस वाक्य का परिधि क्या है, इस वाक्य का प्रभाव क्या है, इसका मतलब क्या है, इसका अभिप्राय क्या है, इत्यादि इत्यादि. और इस सब चीजों में न्यायपालिका की हस्तक्षेप अनिवार्य हो जाएगा, निश्चित होगा. मैं आपको 2-3 बड़े रोचक उदाहरण देना चाहता हूं. आज पूरे भारत में कई दशकों से जब चुनाव होता है तो आदर्श संहिता जो चुनाव आयोग करती है, मॉडल कोड ऑफ कंडक्ट जिसको हम कहते हैं, उसको सब लोग मानते हैं. पार्टियां भी घबराती हैं, मेंबरान भी घबराते हैं, उसका पालन करते हैं. लेकिन वो तो कोडिफाइड. आपको आश्चर्य होगा कि मॉडल कोड ऑफ कंडक्ट, आदर्श संहिता, न किसी कानून में है, न संविधान में है, न स्टैट्यूट में है, न पार्लियामेंट्री लॉ में है, कि है ही नहीं. एक कागज का पत्ता है जो चुनाव आयोग ने कई दशक पहले जारी किया था. इससे कोर्ट, न्यायपालिका का हस्तक्षेप मॉडल कोड ऑफ कॉन्डक्ट में बहुत कम है, क्योंकि एक ऐसी चीज है जो स्वयं पालन करने का, आंतरिक रूप से अपने विवेक से हम लोग सब पालन करते हैं, उसको जब आप कानून में बदल देते हैं तो वो एक आरोप प्रत्यारोप का एक विषय बन जाता है. एक और उदाहरण है बड़ा रोचक, बेसिक स्ट्रक्चर डॉक्ट्रिन. इंडिया इज द प्राउड इन्वेंटर of the basic structure doctrine. India is the pride of the world, is the pride of India, it is the envy of the world, because according to me, India can never be a dictatorship for long because of the basic structure doctrine. As you know, Keshwananda Bharati, 13 judges sat by a 7-6 split, they promulgated. Basic structure doctrine, why is it so important? It is because it says that even a constitutional amendment passed by 2/3 of members of parliament can be unconstitutional. Suppose all of us sit together and this is a parliament and 2/3 of you say that India shall be a theocratic state, or India shall have a president for life. Now, if 2/3 of people pass the law, it becomes a constitutional provision. Why can't you pass it? Of course you can pass it. But it will be struck down, even though it's a constitutional amendment, as violative of basic structure. Basic structure is that which is the Atman, the soul of the constitution, that which is the inherent character and nature of our system, and that can't be amended, is what the basic structure doctrine says. But now coming back, why am I saying this for privileges? Basic structure has deliberately and consciously not been defined by the Supreme Court. Basic structure was invented in 1973. Today we are 45-50 years later. In no case have they defined it. In one case they say that free and fair equal vote is basic structure. In one case they say Republican form of government is basic structure. In one case they say democracy is basic structure. In Bombay they said federalism is basic structure. In many cases they've said secularism is basic structure. But they've not issued a list saying basic structure is 1, 2, 3, 4, 5 and it stops at 5. They keep on a dynamic evolving process adding to basic structure. That leaves the last word with the judges. That leaves the last power with the judges. They have not codified it. And that gives flexibility in the joints. That is why my own view is do not codify privileges. Now this is easy to say, it's interesting. This was raised in the Constituent Assembly. Ambedkar's view was that we cannot, he was not against codification, but he said do not codify, wait for some years and see how privileges work out, then we will consider codification. He said so in the Baba Sahib. Then there were various meetings in 1921, a presiding officers conference. In 1933, it's very interesting, there was a debate on the Government of India bill, which later on became the 1935 Government of India Act. And we sent from India, they sent a memorandum to UK saying, please codify our privileges. And the UK Parliament said, no, we are following a system in England, we will also not codify yours. We don't want to codify. Because when 35 Act was being made, the proposal was to codify privileges. Mavlankar, one of our great speakers, consistently opposed codification for the reason that gives flexibility if you don't codify, prevents intrusion and invasion of your rights. 1950, there is a report of Committee of Indian Speakers against codification. The judiciary has attempted codification also. There are judgments where it was attempted, but ultimately they said no, Parliament has to do it, we can't do it. In 1965 Speakers Conference in Bombay, no codification. In 1992, a conference of chairmen of all the committees of privilege of Parliament and all the state assemblies, Privileges Committee, again report, don't codify. And in 2008 is possibly the most comprehensive 11th report of the Committee of Privileges itself. So they said generally this power is not used much, so don't codify, etc., etc. So generally the view is against codification, but I have given you very nuanced views as to why you should not codify. And I have given you the analogy of Model Code of Conduct and basic structure. Another issue arises, should you not have one committee of Parliament for privileges? Today we have two. One in Lok Sabha House, I'm sure there must be some Lok Sabha members here, and one in our house, Rajya Sabha, to where I belong. It may not be bad today. I think Lok Sabha is 15 members, I don't remember, and Rajya Sabha is 10 members, possibly. I am also a member of the Committee of Privileges, but we haven't had any major action on that front. Maybe it's a good idea to merge the committees. One of the reasons in the old days why they said don't make a single committee was, what happens if I as a Rajya Sabha member make a alleged privilege against a Lok Sabha member? Or what happens if a Lok Sabha member makes a comment which is allegedly breach of privilege against a Rajya Sabha member? That was the argument given for not having a common committee. That of course is not a very great argument, because the procedure now is that if I as a Rajya Sabha member raise an objection against you as a Lok Sabha member on privileges, then it goes to the presiding officer of your house, the other house. And then that presiding officer can of course end it there, or he can then decide whether to refer it or not to his own committee, that is the Lok Sabha committee. Interestingly, this question arose very interestingly. You know, many of you were not there when he was there, Somnath Chatterjee. His father, N.C. Chatterjee, once as a Lok Sabha member, called Rajya Sabha members, quote unquote, a pack of urchins. A pack of urchins. So they initiated privilege against him. And that's how the question arose about one member being sued by members of the other house. But that can easily be resolved by having the chair of a common committee deciding it. So I don't think that's a great reason. So personally I am of the view that you should merge these committees to get greater force and integrity, because Parliament as an institution exercises privilege. Lok Sabha does exercise privilege, Rajya Sabha does exercise, but ultimately Parliament as an institution must exercise. Actual penal action under privilege, and I'll come to the degrees of penal action, has been statistically few and far between. I would like some figures from the Secretariat on this, but somewhat 10-year-old figures, 2008-10, till about 2008-10, which is about 60 years from independence, we've had only one case of admonition, 2 cases of reprimand, and 1 case of expulsion, as far as Lok Sabha is concerned. So in 55 or 60 years, Lok Sabha had 1 case of admonition, 2 cases of reprimand, 1 case of expulsion. And Rajya Sabha had 2 cases of reprimand only, no expulsion. I'm sure there must have been 2 or 3 more, but it's not a large number. It's not as if Committee of Privilege has gone amok, trying to take penal action against all and sundry. In fact, courts have been more intrusive. And one of the interesting issues of balancing, and I'll come to these judgments a little later in different contexts, there are very interesting fact situations there. But one principle of some difficulty arose in both Keshav Singh in 1959 and in MSM Sharma 1959 and Keshav Singh 1965. And the question arose is that you have free speech under 19(1)(a). You know 19(1)(a), free speech and expression, fundamental right, part 3. Well, then that free speech should allow you to say what you like, and Parliament can't punish you for that. And there cannot be, therefore, a parliamentary privilege under 105 of the Constitution which prevents or controls or reduces the free speech right under 19(1)(a). This was the question in these cases. Now that's an important question because 105 protects privileges of Parliament, it's in the Constitution. 19(1)(a) also gives you free speech rights, it's in the Constitution. Both are in the Constitution, one is a fundamental right. The court did a balancing exercise and ultimately held no. 19(1)(a) will be subordinated to 105. That means 105, you can punish for breach of privilege even if somebody is exercising his free speech right. 194 is for the state assemblies, 105 is for Parliament. But then they added that fact that privileges will prevail over even free speech right in 19(1)(a) will not apply if the right to life Article 21 is involved. So in the right to life Article 21 case, Article 21 will prevail over 105. These are two 5-judge benches, very famous cases. MSM Sharma is very interesting, I'll tell you in a minute more about it. Searchlight case. The man was a newspaper called Searchlight, he published. He said, I have a free speech right to publish in newspapers. What is happening inside Parliament? Parliament had expunged. I'll come to that in a minute. So, the law today as it stands is that the right of free speech of an editor or a journalist or a newspaper or a TV channel to do something which parliamentary privilege doesn't allow will be subordinated to parliamentary privilege. In other words, parliamentary privilege will prevail. But if it impinges on his right to life, Article 21, then 21 will prevail. Of course, it all depends on how you interpret. I have said elsewhere in another lecture that Article 21 has become a laundry list of every right. People have said the courts have gone to the extent of saying right to good air, clean air, right to live with dignity, right to have clean water, right to have hygiene is all part of 21. Now if you start applying 21 so widely, then no parliamentary privilege will be left. So you need to be fair and balanced in applying it. Let me give another example, which is more recent. I happen to argue that case, the Facebook case, which gives you the dialectics of the balancing which the court has to do. It is interesting because it's 2022 only, decided in 21 but reported in 2022 by Supreme Court. The Delhi Assembly has a committee, the NCT Assembly, which is called the Peace and Harmony Committee. It's a part of the Assembly and it is privileged, just like the Assembly has privilege. They decided to inquire into how to create preventive safeguards for preventing recurrence of the Delhi riots which happened recently after many decades. It's a serious matter for Delhi, so they said we'll look into it. Facebook said, they issued summons to many people, including Facebook, saying you tell us how you can strengthen your mechanisms to prevent conflagration, to prevent provocation, to prevent an incendiary atmosphere which will lead to conflagration between communities or people. The Facebook fellow refused to come. One of the main arguments he took was NCT has got only power under 1, 2 and 18 of the NCT has power not under 1, 2 and 18 of the list 2. That is, one is law and order, public order and this land. These 3 are not NCT subjects. And what you are asking me questions about in a parliamentary and in an assembly committee relate at least partly to these. And I will go before parliamentary committee, and they have also called me separately. Some committee here had also called them, but I will not come to you. So he filed a writ, and we had occasion to argue in Supreme Court. Mr. Salve appeared for the Facebook, I appeared for NCT. And the judgment has come, which I think is the right judgment, not because I succeeded, but otherwise also, in principle. They said that the powers of committees are very, very wide. And the power to summon is very, very wide. And peace and harmony certainly falls in their jurisdiction. And if you don't come, you will be committing a breach of privilege. And they'll be in their rights. Of course, if you come and they ask you questions which relate to entries 1, 2 and 18, land or particular things which fall in the jurisdiction of central government, then possibly courts may interfere. But today on a mere summons, you can't say I will not go. Full privileges apply. This also is actually best illustrated for those who are interested in reading in a judgment called Kalpana Mehta, 2018, volume 7, SCC, page 1, which has suggested how for committees of parliament, privileges committees or standing committees also, the entries have to be interpreted very widely. You can't interpret the entries of list 1, list 2, list 3 narrowly, which is what Facebook was trying to do. The judgment also makes it clear that privileges apply to non-members, that is, privileges apply against non-members, not to, against non-members. It is not that I, as a parliamentary committee of privileges, cannot call a non-member. One of the arguments of Facebook was that parliamentary privileges apply amongst your own community. I cannot be guilty of breach of privilege for not coming in a summons. Now, it is well established that if I, as a parliamentary committee, issue summons, and you don't come without valid reason or legal defense, then it is a breach of privilege. It is a breach of privilege. Another delicate balance is required. One delicate balance I told you, 19(1)(a), publishers outside publishing. One is this committees calling on restricted entries. The third aspect arises when you have proceeding inside parliament or for that matter assemblies. It is well established that you will not have any court interference. So what you do as a speaker inside or what we talk inside is you can't have. That's well established. There's an article also in the constitution, article 212, article 121 for parliament and assemblies, that they cannot scrutinize. But sometimes extreme measures happen. For the cash for query, cash for question scandal, members were expelled. That is the last and the extreme form, expulsion. They went to court. The question which arose in Raja Rampal, case name in 2007, was first and foremost to what extent and degree can we look into it. Well, this happened within the house. They had to strike a delicate balance. First they said we uphold the expulsion. Second, this relates intrinsically to how you run the house. And that is entirely the speaker's domain. So if somebody creates a problem in the house, the speaker decides to reprimand him, expel him, whatever, suspend him, that is his job, we can't interfere. But they left a window open saying that if there are very gross violation of fundamental rights, then we'll have a right. And they went back to MSM Sharma and Keshav Singh that article 21 जहाँ पर होगा, वहाँ पर हम हस्तक्षेप कर सकते हैं. तो एक विंडो खुला छोड़ते हुए उन्होंने कहा कि निष्कासित करने का, एक्सपल्शन करने का जो अधिकार क्षेत्र राजा रामपाल में किया गया था, उसको हम वैध मानते हैं, वैलिड मानते हैं. लेकिन हमारे पास अधिकार क्षेत्र है कि किसी अमुक केस में अगर आपने अनुच्छेद 21 के विषय में कुछ ऐसी बात की तो हम हस्तक्षेप कर सकते हैं. इसका एक उदाहरण अभी हाल में आया है महाराष्ट्र से, जहां की सस्पेंशन एक्सपल्शन नहीं था, 1 साल के लिए हो गया. तो वहां पर कोर्ट कचहरी ने हस्तक्षेप किया और कहा कि उस सेशन तक या उस सेशन के अंतिम दिन तक आप कर सकते हैं, या कभी कभी बहुत एक्सट्रीम केस में कुछ महीने तक कर सकते हैं, लेकिन एक पूरे वर्ष के लिए कई सेशंस के दौरान आप सस्पेंड नहीं कर सकते। तो हस्तक्षेप किया। पार्लियामेंट में बोलने का जिसका पूरा अधिकार क्षेत्र है, जो प्रिविलेजेस सबसे ज्यादा प्रोटेक्ट कर, जो शुरुआत हुई थी इस पूरे की 1000 वर्ष पहले ब्रिटेन में, वो इसी बात की हुई थी कि आप पे कितना अधिकार क्षेत्र है, कितना इम्यूनिटी है स्वतंत्र बोलने की संसद के अंदर। उसके विषय में एक बहुत ही अजीबोगरीब केस है, और केसेस बड़े अजीबोगरीब होते हैं कई बार। उस केस का नाम है नरसिम्हा राव वर्सेस स्टेट, 2000 आई थिंक 1995-96 का था, 97 का था उनके जाने के बाद। ये अजीबोगरीब इसलिए है because the issue here was that people were accused of receiving bribe and then speaking inside parliament on the basis of bribe and voting inside parliament on the basis of bribe. So I received 100 rupees to vote like this inside parliament, and you received 200 rupees to speak this in parliament. Now the question arose, will they be prosecutable under the Prevention of Corruption Act? क्योंकि bribe थी. The defense of the members was, and this tells you how interesting these things can become, that assuming I received the bribe, assuming I spoke inside parliament after receiving the bribe, the allegation is I spoke because of the bribe, but ultimately I spoke and voted inside parliament, that is covered by parliamentary privilege. And you can't prosecute me even though I received the bribe for a offense, because that money is intrinsically related to how I voted and how I speak. And how I vote and how I speak is completely covered and protected. So some clever lawyer gave a very clever, good defense. Now, you will be astonished that 3-2, this defense succeeded. Court split 3-2. 3 judges said, yes, you cannot be prosecuted under Prevention of Corruption Act. 2 said, no, you can be. The reasoning was very interesting. Justice Bharucha the hamare Chief Justice. He used to go strictly by law, technical law. And only he could write it. I think it's a wrong judgment completely. It has to be overruled. It has now been referred to larger benches for reconsideration. But Justice Bharucha, heading 3 people and 2 dissenting, held. Very interesting. He said, we are all agreed that voting and speaking in house is protected. Technically, I can abuse anybody I like, and I can't be prosecuted for defamation, as you know. As they say, if you want to defame somebody, go and speak inside parliament, don't speak outside. So, he says that you are protected fully by privilege for speaking or voting in house. Now, assuming that a bribe is given, the bribe is inextricably intertwined and related to what you speak and do in parliament. Therefore, you can't be prosecuted because you are protected by privilege. But then he said, suppose you receive the bribe and don't vote. And suppose you receive the bribe and don't speak. Then you are not exercising the parliamentary privilege of voting or speaking. Then you would be prosecutable under the Prevention of Corruption Act. एक्चुअली ये हुआ, ये झारखंड का मामला था। झारखंड के कुछ एमपीज के विरुद्ध आरोप था कि उन्होंने ब्राइब रिसीव की है। तो उस ग्रुप में जिन्होंने वोट किया और बोला, वो प्रोसिक्यूट नहीं हुए, वो बरी हो गए। और आज भी वो प्रोसिक्यूशन चल रहा है उनके विरुद्ध जिन्होंने वोट नहीं किया, बोले नहीं, क्योंकि प्रोटेक्शन ऑफ प्रिविलेज अराइजेस फ्रॉम दिस। 3-2 जजमेंट। दिस जजमेंट इज रॉन्ग, इट इज रिडिकुलस, देयर कैन नॉट बी एन इम्यूनिटी। इट हैज बीन रेफर्ड to a larger bench, and it is pending for reconsideration before a larger bench. But today the law is as it stands. I am sure if it goes to court again, people will find ways around it. ये एक केस हाई कोर्ट में अराइज किया झारखंड में, अभी हाल में झारखंड हाई कोर्ट में, और उन्होंने इसको डिस्टिंग्विश किया इसी ग्राउंड पे कि आपने पैसा तो ले लिया लेकिन वोट नहीं किया या ब्राइब नहीं किया, एब्सटेन किया। इन तीनों केसेस में आपको ये privilege लागू नहीं होता है. But this is the law as it stands. Friends, it is now 10:45. I'll just take very quickly, and this very important thing coming up, so I'm beyond time, but I have to race ahead. Let me just give you a few points and end. So you have a right to free speech inside Parliament. Is that right absolute? Answer is no, can't be. There are rules inside the House of how you speak, how much you speak, what you can speak. I can't get up and start abusing a judge, although I can't be sued for defamation. You can't be sued for defamation. It doesn't mean I can get up and there rule 238 hai. इस तरह के, so you are bound by the rules. Number two, you are protected within the House. What happens if you publish the same thing on Twitter or if you publish the same thing in a newspaper? Well, my view is that if identical words spoken in a house, provided they are identical, are published even by the member on Twitter, it would still be protected. But if the member publishes it by adding mirch masala and writing more, then it will be liable for defamation because it goes outside the house. Number three, does privilege protect you against the whip, the party whip? Because you have a free speech right on privilege inside the house. So how can you obey a party whip? You can speak what you like. Answer is no. You can speak what you like. Parliament protects that. But equally the party can punish you. So party whip, you cannot defend by saying I have a free speech right. Fourth, do people other than MPs enjoy privileges? Answer yes. For example, the Attorney General under the Constitution of India can come and speak in Parliament. So, for example, you are a minister who is not elected to either house. So, you are not an MP. Will you have parliamentary privilege? Answer is yes. Therefore, I read the Article 105. It applies not only to MPs but all those who are like MPs. In other words, those who have to discharge duties inside Parliament. That includes a minister who is not an MP, it includes the Attorney General, it includes other such special categories. As far as arrest is concerned, civil arrest is not possible. But criminal arrest is with only a duty to inform and intimate. In England, this intimation to the chair arose because the House had to know where he was kept, because he used to travel on horseback to Parliament after many days of riding. So if the man did not reach, they needed to know where he is. So that is how this provision arose, that you must inform the chair, but you cannot prevent arrest. A major issue in the courts is, why should you not be brought from jail to vote? It's a privilege to vote. It's a privilege to. Yes, since you are jailed, you cannot speak, but why can't you be brought? Today the law as it stands, except for some elections, which is a special category like presidential election, etc. For elections, normally a person, a member of parliament or an assembly member who is jailed cannot be brought. And cases filed by them recently in Maharashtra's council, this thing happened elsewhere. The court has not given relief, saying that no, if you are jailed, you lose your right to vote. Jail makes you lose your right to vote. Obviously, these are all matters which have to be applied in a sensible, balanced way. You can't say that there is a parliamentary privilege against me because I was held up in a traffic jam or because my train and plane got late, so I will issue a notice of privilege against the airline. So these have to be done because they are intended to protect your right to function effectively. It doesn't mean you will start abusing the privilege itself by making such claims. The procedure is well known. You as a member complain to the chairman by a simple letter. The chairman then looks into it. You can even say that I want to move privilege in the house itself. If the chair permits you, you can do it. 99% the chair never permits. The chair looks at it first, and if it finds that there is some prima facie case, it refers it to our committee of privileges. Each house has a separate one, as you know. What are the graded hierarchy of penalties? I'm sorry, I'm rushing a little bit because I'm out of time. One is admonition. It's like a warning. They issue a small little warning. They don't do it again. Second is reprimand. Reprimand means you are called to the bar of the house and the whole house collectively through the speaker reprimands you. The chair reprimands you on behalf of the speaker. It happened once when Dr. Shankar Dayal Sharma, then Vice President, Chair of Rajya Sabha, was subject to some bad remarks, and that member of parliament, whose name I forget, was called to the bar of the house and reprimanded. But it doesn't happen frequently. Third is jail, arrest. As I said, hardly ever happens, and normally on 99.9% it is to the duration of that session. Another extreme form, of course, even more extreme, is expulsion. I've told you Raja Rampal upheld the expulsion on cash for questions. Long suspension of 1 year or 2 years, as happened in Maharashtra for 1 year, has been held to be bad. Because suspension is nilambit karna sirf. You can't suspend in a way that it equals almost expulsion. Can't be over 3 sessions. In 1 year will be 3 or 4 sessions. Bizarre things can happen. No, one other question before that. Can't you move a privilege motion against the chair? Why not? The chair is also some form of member of parliament. The answer is no. The chair is the custodian. You can ask for removal of the chair. You can ask for a no confidence motion in the chair. But as far as I know, although it's not directly decided, you cannot have a privilege motion against the chair. Bizarre things happen. And you must note these 2 incidents, or one incident, actually 2 or 3 incidents. One happened in England in 1769. That is 300 years ago. A chap called John Wilkes, who was a very feisty, energetic man. He fought an election from Middlesex and entered Parliament. And Parliament said after some time that you have been an outlaw. We were talking of 1769. Something like Robin Hood. So we expel you. We exercise our privilege to expel you. He went back. उस वक्त चुनाव तुरंत होता था क्योंकि vacant हो गई seat. He fought again for Middlesex, telling them that look, this parliament is foolish. They have expelled me. I am your representative. You jolly well elect me again. So they elected him a second time. When he reached parliament, parliament again expelled him. He went back and fought a third time. He again won and came back. This time parliament relented and things quietened down. They realized that the people want him and they stopped expelling him. So these are all under privileges. These are all under parliamentary privilege that he was expelled 3 times. Expunged content has been the subject of many cases. I mentioned 1965, 5 judges, M.S.M. Sharma. It happened in Bihar. An opposition member made very derogatory comments against the then Chief Minister of Bihar. There was uproar and pandemonium inside the assembly. The speaker, trying to help, intervened. The members, some of them, went after the speaker so much so that they tried to snatch his dhoti. The speaker ran and took refuge in his chamber. Later on, after some hours, everything quietened down. People apologized. Speaker came back. But rightly he said, all which happened from the time you went after me and before that till now, I am expunging. So the entire event was expunged. Next day, one Mr. M. Sharma, who was the editor of Searchlight newspaper, he published only the facts. He said, this is what happened yesterday, 1, 2, 3, 4, 5, I am publishing the facts. They issued breach of privilege. How did you publish expunged material? He went to court. He said, this is my free speech right, 19(1)(a). I have a free speech right and I have not reported wrong. This actually happened. They said, no, they have a privilege. The court held against him. They dismissed his petition saying, no, there is a privilege. The privilege includes the privilege to record what they want to record and to expunge what they want to expunge. And once expunged, you can't. Now notice how the march of technology and the march of time has changed this. Poor M.S.M. Sharma was pre-TRP ratings, television channels, 24/7 television. M.S.M. Sharma was pre-instant reporting, like instant coffee. Now suppose the same thing happens And simultaneously this is happening, people are running after the poor man's dhoti and somebody is reporting it. And later on, you see, normally expunction happens in the evening. When the proceedings go, the chairman sits, he says, I will expunge this, I will not expunge this. So it's a time lag of 4 hours. In 4 hours, the whole world has seen it. That can't be parliamentary privilege, even though expunged later on. Of course, if I expunge it today evening and tomorrow you still freshly publish it in some form, then there may be parliamentary privilege. These are realities. Also, as I end, it is all about wisdom, maturity, balance, harmony, reciprocal respect. I am the master of this chamber, you are the master of that chamber, you are the master of a third chamber. That reciprocal respect, restraint, lack of ego. 99% of these are ego issues. The facts in the other case of Keshav Singh were that somebody published, so the speaker said, how the hell did he publish? I will call him here, arrest him. So he gave a summons, that man went to the High Court, a division bench of the High Court gave a stay against arrest. So the speaker the next day said, you issue a warrant of arrest for the 2 judges. This is Keshav Singh, 1959. This is how our law of privilege is established. If you didn't have crazy situations, you wouldn't get the law established. So he issued an arrest warrant against the judges. So the 2 judges ran from Lucknow to Allahabad, and 28 judges, all 20, उस ज़माने में उत्तर प्रदेश में 28 judges हुआ करते थे. All 28 sat together in 1959 and said, we stay the arrest by the speaker against 2 of our judges. So the speaker threatened to take further action, at which point Nehru intervened. He was the Prime Minister then, and said that I am referring it under advisory jurisdiction to the Supreme Court. Under Article 143, he referred it, and Supreme Court gave the judgment, which is known as the Keshav Singh judgment. And there they said, no, you must have restraint and all, but in 19(1)(a) free speech, Parliament prevails. But on 21, maybe it will not prevail. So these require restraint. They require balance, maturity, harmony, reciprocal respect. Friends, I have come to the end. I think it's an important area to realize where you strike the balance. It's an important area to know, as I said, I started with the word privilege. You are a member of a privileged club with special privileges. It's been a privilege to speak to all of you, but equally we must all be clear how not to abuse our privileges.